Okay, well, welcome everybody to this landlord lockdown training webinar with our special guest today, who is Barrister Dean Underwood of Cornerstone Barristers. Dean is a specialist housing barrister, and he specialises in particular in HMO issues and HMO licensing. So, Dean, welcome.
Tessa, thank you very much. And as ever, thank you for the invitation to speak at one of your webinars. It's always a pleasure. Well, everybody, we have only a short time available to us today, so I'm going to press on. As you'll see, the title to today's webinar is 3 Key Developments in HMO Licensing. And the 3 particular developments that we will be looking at are recent decisions of the appeal courts and tribunals, in particular the Upper Tribunal and the Court of Appeal, in the 3 cases you see listed on your slide. Recusing and Jepsen in the first instance, Hussein and Waltham Forest, London Borough Council in the second, and I think our gremlin has struck, and Sutton and Norwich City Council in the third. Throughout the slides, as I've done previously, you'll find links to various of the decisions and the materials to which they refer. Those are links to web pages where you'll find the decisions. If you click on them or right-click on them, you'll be taken through to the relevant materials. Any queries that flow from this, feel free to give me an email.
I just mentioned briefly, Dean, that they can't download the PowerPoint at the moment, but when the recording is put online on our YouTube channel, which is the Landlord Law YouTube channel, I will put a link through to the slides so that people can get them.
That's fine. I'll try and bear that in mind. Well, the first of the cases that I intend to look at is a case of Recusing and Jepsen, which, for those of you who can see the slides, is now appearing on your screen. Recusing and Jepsen is an interesting and important case in which the Upper Tribunal had to determine whether the first-tier tribunal had jurisdiction to make a rent repayment order against the landlord other than the applicant's immediate landlord who had committed an offence to which the Housing and Planning Act 2016 applied. For example, failing to license, as in this case, a house in multiple occupation. As far as the background goes, Jepsen, Murphy and MacArthur, I believe, were tenants of a flat in Finchley. Their immediate landlord was a company called Kensington Property Investment Group Limited, and the superior landlord in that case was Mr. Recusing, who ended up as the appellant before the Upper Tribunal. In that case, the tenants had applied for a rent repayment order, not against Kensington, their immediate landlord, but against Mr. Recusing under Part 2 of the 2016 Act. Mr. Recusing had then applied to strike out that application, and his argument was that under Part 2 of the 2016 Act, the first-tier tribunal only had jurisdiction to make a rent repayment order against a landlord, in inverted commas, and by that, he said, the statute meant the immediate landlord and the immediate landlord only. Well, the first-tier tribunal dismissed his application, and as a result of that, Mr. Recusing had appealed to the Upper Tribunal against that decision. The appeal to the Upper Tribunal turned on the proper interpretation of Section 40 of the 2016 Act, which is the first section in Part 2 dealing with rent repayment orders. And the Upper Tribunal, in summary, dismissed his appeal. Why? Well, amongst its reasons, it held that in Section 40, the use of the word repay did not in fact mean that a rent repayment order could only be made against the person who received the rent paid by the tenant. As a matter of language, it held, there was nothing particularly incongruous in referring to a sum being repaid by a person who was not actually the original payee. The essence of repayment, it held, was that it was a sum paid back to the person who originally made the payment. And so it was not indispensable that the person making the repayment should be the same person as received the original payment. or indeed that only two parties should be involved. Additionally, it held that the draftsman of the 2016 Act had chosen to use the indefinite article A as opposed to the definite article the to refer to a tenant in section 40, subsection 2. And that, it held, meant that there was no need for an immediate relationship between the respondent landlord and the tenant applying for the rent repayment order. And in that regard, it held it was instructive that each of the offences under section 40, subsection 3, for which a rent repayment order could be made, which of course included failure to license a house in multiple occupation, could be committed by a superior landlord. It was also instructive, it held, that the draftsman of the legislation was departing from the approach taken in the 2004 Act when identifying those against whom the original rent repayment order could be made.
Can I just say here, I think somebody may be moving the slides. If I could just say that we have a bit of a gremlin with the system today, and a number of people have in error been logged in as admin. If this is you, can you please not touch any of the controls? And in particular, can you not move the slides while Dean is talking? Thank you.
Especially when I'm reading from them.
Yes.
That would be very helpful. But we will manage, not to worry. So as I was saying, I was talking about the 2004 Act, which of course had originally enacted a scheme for making rent repayment orders. And the tribunal noted that originally rent repayment orders were provided for under Section 73 as a sanction if a house in multiple occupation, which was required to be licensed, was not in fact licensed. And the whole purpose of the 2016 Act, Part 2, had been to expand the original jurisdiction under the 2004 Act from a single offence relating to HMOs to a much wider range of housing offences. And so it wasn't improbable, it held, that Parliament had intended that the expansion should also expose a wider category of landlords who had committed these new housing offences to the risk of a rent repayment order. And so it held that there was no other policy reason why the objective of deterring such offences shouldn't extend to superior landlords. Ultimately, therefore, it concluded that the first-tier tribunal had in fact had jurisdiction to make a rent repayment order against Mr. Recusing, even though he was a superior landlord. It held that in fact it could make one against any landlord who had committed an offence to which Part 2 applied, including a superior landlord.
So in effect, Dean, this means that a landlord can't protect themselves from rent repayment orders by subletting the property under a rent-to-rent arrangement.
That will, in and of itself, not suffice, no.
So, yeah.
It's a cautionary tale. As the slide says, or when you see the slide, you'll be able to see superiority is no bar to a rent repayment order.
Mm.
So the only jurisdictional filter is that the landlord in question must have committed one of the relevant offences, of which, of course, the first-tier tribunal has to be satisfied of to the criminal standard. But it will not matter necessarily that the landlord is not the immediate landlord.
Yeah.
Well, that is a whirlwind tour, if you like, of the facts and the findings in Recusing and Jepsen. Let me take you to the second of the cases that I want to look at, which is the case of Hussein and Waltham Forest, London Borough Council. Now, this is
Dean, I wonder whether I ought to ask you very quickly about a question that we've had, which says, under Recusing, what is the position of a landlord whose tenant unlawfully sublets contrary to the tenancy?
Well, in that case, and that's a point on which I'll touch when I come to look at Sutton and Norwich.
Okay.
It may be, briefly, it may be that those facts will give rise to a reasonable excuse, and that therefore, if there's a defence of reasonable excuse, the offence would have been committed such that a rent repayment order can't be made. But whether there is a reasonable excuse will depend on the facts and is an objective question for the tribunal to consider.
Okay.
So Hussein and Waltham Forest, London Borough Council is a case that I've talked about previously on one of your webinars, I believe, Tessa. But that was at the stage when it was before the upper tribunal. It has since progressed to the Court of Appeal, and we now have an appellate decision from that court. Well, as far as the background to Hussein is concerned, the appellants in that case were husband and wife, and they appealed against a refusal of their applications for licenses to let out houses in multiple occupation, and also against the revocation of numerous existing HMO licenses. So the first appellant and her husband owned and managed residential properties, which they rented out. The properties were subject to HMO licensing requirements under Part 2 of the 2004 Act, and possibly Part 3 as well. In 2016, the first appellant had applied, that's the wife, had applied for licenses for 7 properties, and she had falsely stated that they did not have any gas appliances. And she'd made, unfortunately for her, similar false assertions in 2015 in relation to, I believe, 21 license applications. When the local authority challenged those made in 2016, her husband produced forged gas certificates, and he was duly convicted of forgery. And those convictions, importantly, became spent in June 2019 under the provisions of the Rehabilitation of Offenders Act 1974. The first appellant, his wife, was also convicted of offences, in her case of supplying false information, and her convictions became spent under the 74 Act in May 2018. In reliance on those spent convictions, however, the authority had refused the 2016 applications and went on to revoke 29 existing licenses held by the appellants. They appealed against that decision to the first tier tribunal and applied to strike out parts of the council's statement of case, which they claimed contravened the provisions of the 74 Act, which they said prevented the council from relying on their convictions because they were spent. And the question before the first tier tribunal at that point was whether Section 4 of the 74 Act, in particular subsection 1A, which prohibited the admission of evidence in inverted commas in any proceedings before a judicial authority relating to the offence committed by a person whose conviction had become spent, whether that also covered the admission of evidence relating to the conduct underlying that offence. The first tier tribunal, some time ago now, upheld the authority's decision and refused to strike out the application. So they appealed to the upper tribunal, which of course is the decision about which I've spoken previously. And the upper tribunal held that Section 4.1a didn't exclude the admission of evidence concerning the conduct underlying an offence. And it also held, importantly, that judicial authority, as referred to in Section 4, included not just the first tier tribunal, but actually also the local housing authority when performing its licensing functions under Part 2 of the 2004 Act. And dissatisfied with that decision, the appellants appealed further to the Court of Appeal. They got, unfortunately for them, rather short shrift. The Court of Appeal dismissed their appeal and found that the upper tribunal had correctly found that Section 4, subsection 1a, unlike other provisions in Section 4, which referred to any conviction or any circumstances ancillary thereto, did not prohibit the admission of evidence concerning the conduct beneath or underlying a spent conviction. In that instance, the court held the statutory words were clear, and it was permissible to consider evidence of that conduct. As to whether the local authority was a judicial authority, strictly that issue didn't in fact arise on the facts of the case, because by the time it got to the Court of Appeal, the court was concerned not with the position before the local housing authority, but actually the position before the upper tribunal, who stood in the place of the first tier tribunal on appeal from the local authority's decision. But it held, which in a statement which must be obiter dicta, the wide definition of the expression judicial authority in Section 4 extended beyond those who adjudicated between third parties and extended to persons and to bodies such as the council, who had the power under a statute to determine questions which affected the rights and obligations and liabilities of persons, and to receive evidence affecting the determination of those questions. And so that included an authority empowered by statute to determine, as in this case, the grant, refusal and revocation of licenses under Part 2 of the 2004 Act. And so in those cases, authorities such as the council, exercising its functions under Part 2, had the power to disapply the prohibition in the 74 Act, which prohibited reference to spent convictions, and to admit evidence of a spent conviction if it was satisfied that justice could not otherwise be done. So not only was it possible to admit evidence of the conduct which lay beneath a spent conviction, but if the interest of justice required it, the spent conviction itself could be relied upon, not just by the first-tier tribunal, who of course is a judicial authority, but also by the local housing authority, who is the first instance decision maker. So the moral of the story is, even if you are convicted of an offence and that conviction becomes spent, in the context of licensing, the conduct underlying the offence, and indeed in certain circumstances, the conviction itself can still be relied upon by the council when, for example, determining issues such as your fitness to hold a licence under Part 2 or Part 3 of the 2004 Act.
Dean, I think someone's moved your slides. Has someone? Yes. Could you say? Could I just say to people who've come in, there is an error in the system. Some people in error are being logged in as me and have controls. In that case, can you please not touch the slides? Because this is being recorded and it's going to, you know, we need to have the correct slide on the screen. So please do not move them backwards and forwards. Thank you. Sorry, Dean.
Yes, to avoid any issue with that, I've taken to reading from my notes.
Yeah.
So that I'm not disturbed, as it were, by the moving slides.
Yeah, but I think they need to be on the correct slide. Otherwise, it's going to be confusing for people watching.
Indeed.
So perhaps I might move them back. Perhaps you could say when you're moving the slide, and if somebody moves it back and forward before then, I'll just move it back again.
Yeah, of course, I will do. Well, that brings us to the end of Hussein and Waltham Forest concerning spent convictions. In short, the position that we discussed previously when we talked about this matter before the upper tribunal has been now upheld by the Court of Appeal. I understand that there may be an application for permission to take this matter to the Supreme Court. I may be wrong about that. Certainly, if there has been such an application, I'm not aware that it has been granted. So watch this space. That brings us to the case of Sutton and Norwich City Council. Again, a case that we have considered in the context of previous webinars, again at the stage when it was before the upper tribunal. And I have moved my slide onto Sutton and Norwich City Council. So if it moves, I will let you know.
Okay, I'll move it back if somebody moves it by mistake. But if people could please not touch the slides.
Well, let's deal first with the background to this case, which was really quite complex and convoluted. So here the council had imposed financial penalties on Mr. Sutton and the company of which he was a director. And in this case, the penalties that they've imposed totaled something in the region of £236,000 each. So they were significant sums. Mr. Sutton happened to hold a 55% share in the company, a point which will become relevant as we proceed with the discussion of this case. The penalties in this case had been imposed for two matters: failing to comply with improvement notices, contrary to Section 30 of the 2004 Act, and secondly, for breaching the 2007 management regulations, which apply to HMOs, in particular, Section 257 HMOs. Mr. Sutton himself was liable personally, as well as the company, because under Section 251 of the 2004 Act, The statute enabled the council to prosecute or penalise the director where the company's offence was committed with his or her consent or connivance, or was attributable to neglect on the part of the director, which it found in this case it was. Well, as you might imagine, given the size of the penalties, Mr. Sutton and the company both appealed on the grounds that they didn't know the house was an HMO, a point to which I think one of our participants recently referred. And secondly, that they had relied on a reputable professional to carry out the works of the house, and so they said had a reasonable excuse for the offences under both Section 30 and Section 234, which creates the offence failing to comply with management regulations. And thirdly, they said that by penalising both the company and its directors, the directors had in effect been punished twice, in particular in Mr. Sutton's case, because he held a 55% share in the company. Well, their appeal to the upper tribunal succeeded in part. Importantly, the upper tribunal held, as far as the offence itself was concerned, under Section 234, that is, failing to comply with the management regulations, that the statute created a strict liability offence, which was only subject to several prescribed defences, one of which was the defence of reasonable excuse. And so once the facts of the offence had been proved by the council, it was for Mr. Sutton and the company to prove to the civil standard of proof, not the criminal standard, but the civil, that they had a reasonable excuse. So they bore the burden, once the offence had been established, of demonstrating that there was a reasonable excuse. And as I indicated earlier, whether that excuse would be reasonable or not would be an objective question for the tribunal, and therefore would depend on the facts of the case. Now, importantly, and this returns to the question that was asked earlier, in principle, ignorance of facts that cause a house to be a house in multiple occupation, for example, a lack of knowledge that the house is in fact occupied by more than one household, in principle, that might provide a reasonable excuse. By contrast, a lack of knowledge of the consequences of those facts, for example, or rather, that is, ignorance of the law, will not provide such an excuse. So if you're aware of the facts, which in law mean that a house is a house in multiple occupation, then your lack of ignorance of the law, which says it requires to be licensed, won't help you. But if in fact you do not know that the house is, for example, multiply occupied, then you may have a reasonable excuse, and that will depend on all the facts and whether objectively those facts amount to a reasonable excuse. In this particular case, the upper tribunal held the penalties imposed on the company and the directors were excessive, and they should have been fixed, having regard not only to the statutory maximum for the penalties, which is £30,000 for each offence committed, but each with regard to the penalty that had been imposed on the other. And the reason for that, it held, was that there was a need to avoid the risk of double punishment, which arose in particular in cases where the director who was penalised also happened to be a shareholder in the company. Well, despite the reduction, and quite a significant reduction, in the penalties that were imposed on them by the upper tribunal, Mr. Sutton appealed further to the Court of Appeal against the amount of those penalties. He did not appeal against the upper tribunal's finding that Section 234 created a strict liability offence, and that remains good law. Indeed, it's been held, the same finding has been made in respect of the offence under Section 72, in a case in which I was involved before the Divisional Court, which was Crown on the application of Mohammed and Waltham Forest London Borough Council. Well, what happened before the Court of Appeal? Tessa, I'm just about to move the slide forwards onto the second slide on Sutton. So Mr. Sutton had argued before the Court of Appeal, relying on a case called Crown and Rollco Screw and Rivet Company Limited. He'd argued that where a company and a director had both committed an offence, the right course was to first ask what penalty the offence itself merited, and then to apportion or divide that figure between both the company and the director. That was an interesting argument, but one by which the Court of Appeal was ultimately not persuaded. The court held that there was no such rule, and whether or not Rolco supported that approach, the fact of the matter was the court had not proceeded on that basis in subsequent cases. And it held there was no guiding principle which was independent of the facts of any given case. But there was equally held no rule as to how the penalty imposed on a company should relate to the penalty imposed on the director. And again, it found there was no real guiding principle and all would depend on the facts. But importantly, it did hold that the previous authorities testified to the need to beware of double punishment, including the Rolco case. So an individual with an interest in a company, could it held be worse off to the extent of some or all of the penalty imposed on the company? And a court had to have that in mind when deciding what fine to impose on the individual director. And it illustrated that point with a couple of scenarios. So briefly, with a solvent one-man company, for example, the importance of avoiding double punishment would loom large, would be very important. The owner of the company might be expected to be the poorer, it held, by the total of the penalties imposed on himself and the company. And so it should not be determined without regard to the penalty that had been imposed on the company. It did add, not as an aside, but as an important point, that the court would nonetheless have to ensure that the penalty imposed on the director confirmed that there was a personal responsibility on directors, which they simply couldn't transfer or pass off to the company. So yes, there had to be a conscious awareness of the need to avoid double punishment, but equally, even then, the penalty imposed on the director needed to send a message. Different considerations, however, arose where a director had only a proportion of the shares or the company was insolvent. So in that case, as indeed in Mr. Sutton's case, and recall he held 55% of the shares in the company, and so a proportion, the extent to which a director's shareholders stood to be affected by a penalty which had been imposed on the company depended on the size of the shareholding. And where the company was insolvent and the shares were worthless, there might be no risk of double punishment at all. More difficult assessments, however, would arise where a company was of dubious solvency or where the penalties were also being imposed on other directors and shareholders. Ultimately, in any event, the court held, the upper tribunal had clearly had regard to the need to avoid double punishment in Mr. Sutton's case. And there was no error in the way in which it had dealt with his penalty. It dealt with a further argument regarding the cap on the penalty under section 249A, which of course is £30,000 per offence. And it held that while there was a cap on the penalty that could be imposed on any particular person in respect of any particular offence, i.e. £30,000, there was nonetheless no bar on the aggregate of penalties imposed on two or more persons exceeding £30,000. The cap, it held, related to the financial penalty on a person, and accordingly, £30,000 penalties could be imposed on both a company and one or more of its directors. It didn't have to be £30,000 split between all of them. As I say, ultimately in this case, the individual penalties that had ultimately been imposed by the upper tribunal were held to be lawful, and the upper tribunal had not erred in its assessment of those penalties. So, as I say, a whirlwind tour of three key developments, and in particular three key cases in the last 6 months before the upper tribunal and the Court of Appeal. You can see that we have now reached, Tessa, the end of my slide, and only 1 minute over time.
Okay, well, I think probably one of the strong messages that comes to me with this is that it's going to be difficult for landlords to protect themselves from liability, in particular under the HMO licensing rules, by either A, having a rent-to-rent agreement, or B, running their property through a company, because this effectively tears the veil of incorporation.
Yes, certainly the courts and the tribunals are extremely skeptical about rent-to-rent agreements. And unfortunately, even in cases where they're genuine, uh, there is a perception, I think, that they are used often as a ruse to potentially avoid liability. Certainly, that won't assist now in light of the Recusing case, because it seems, both in respect of rent repayment orders and indeed the underlying offences. So, for example, failure to license an HMO. It's not only the immediate landlord who can be liable, but also the superior landlord.
Hmm. Okay, right. Well, we have had a couple of questions, but I think probably as we are after the hour, and we do tend to be quite strict about the time limit on this, because this is just a half-hour webinar. We will close down now. So I just want to say thank you so much, Dean, for coming along and talking to us and explaining these very important points,
You're
which,
welcome.
you know, landlords really need to be aware of.
They're certainly very important, and yes, tribunals and local authorities are expecting landlords to be fully aware of their obligations
And to comply with them.
and to comply with them indeed.
And really, the only protection for a landlord is to be fully compliant.
Indeed, yeah, the number of statutory defences to these criminal offences are limited. So yes, there is indeed a great need to be aware of obligations.
Okay, right. Well, thank you very much, Stu, and thank you everybody for coming along. I'm going to close down now. And as I said, the slides will be available via the recording on the YouTube channel later. Thank you.